When I think of Grantor Retained Interest Trusts, or GRITs, I can almost hear Flo from the show Alice saying, "Kiss my grits." But what actually are GRITs? Well, in the world of trusts and estates, a Grantor Retained Interest Trust, or GRIT, is a trust that a person irrevocably transfers property to while retaining a right to income or use of that property for a period of years. A QPERT, as discussed in the previous video, is actually a form of GRIT that is still allowed, but other varieties have been banned. GRATs as well as GRUTs are similar devices, and the differences with them mainly lie in the way the trust interest is paid out. For the purpose of this video, though, I will focus my discussion on GRATs. A GRAT is a Grantor Retained Annuity Trust. With a GRAT, generally older generations in a family will place assets into an irrevocable trust while taking back an annuity payout for a period of years. At the end of this period, anything left in the trust goes to the trust beneficiaries. The trick is to make the remainder interest amount that passes to beneficiaries as large as possible, since that amount generally passes free of transfer taxes. If you're scratching your head at this point, let me try to explain the concept with an example. Let's say I give $100,000 to a GRAT for 1 year, and after the GRAT terminates, whatever's left in there will go to my kids. In order to zero out the GRAT, the government says I must take back $103,000, which is effectively my contribution, plus a 3% rate of interest for 1 year. In this situation, I will have effectively made no gift because everything that I put in the GRAT, I got back. But if in reality my GRAT grew to $110,000 because the GRAT earned a 10% return, then that extra 7% interest will pass to the beneficiaries of the GRAT without facing any transfer taxes. Where contributed assets are large enough, this differential can amount to very large sums of money. But the strategy doesn't always work. First of all, it's important to point out, though, that if assets in the GRAT fail to appreciate beyond its set rate of interest, it's no big deal because the grantor simply paid back the assets originally put into the trust. But also this strategy will fail if the grantor dies during the term of the trust, because all the assets in the GRAT, along with any appreciation, will be included in his or her taxable estate. Plus, more potential problems are on the horizon in the form of new laws. In other words, new proposed legislation would require that a GRAT last at least 10 years and that the remainder interest be greater than zero. This means no more zeroed out trusts. Clearly, these restrictions will make GRATs less appealing. If a minimum gift is required, the grantor probably will have to use up some of his or her $1 million lifetime gift tax exclusion. Moreover, such a long term of years requirement under the proposed legislation greatly increases the risk that the grantor will pass away during the trust term and all the assets will be pulled back into the grantor's estate. So the days of using GRATs may be numbered. Given the administration's apparent desire to curtail the use of GRATs, those considering implementing these trusts should act quickly so that they are subject to the current rules rather than the more limiting rules that might be implemented in the very near future. If you would like to discuss GRATs further, please schedule a free appointment here at the Trust Store.